I'm Katherine Meyer. I'm the director of the Harvard Law School Animal Law and Policy Clinic, where we give students hands-on experience in representing individuals and organizations in their efforts to protect and advocate for animals. And I'm going to be talking about the law of standing. So what is standing and why is it so important? Think about standing as the key to the courthouse door. If animals don't have standing, and they don't in their own right, the question is, how does one enforce the various laws that have been enacted to protect and advocate for the interests of animals? For example, there are many federal statutes that, if enforced, can be used to protect animals from abuse and neglect, other forms of exploitation and mistreatment, including the Animal Welfare Act, the Endangered Species Act, the Marine Mammal Protection Act, the National Environmental Policy Act, and the list goes on. The question is, how are those laws enforced? And the only way to make sure they're enforced is to have someone who has the requisite standing to bring those cases in federal court. And that's why standing is so important. So where does the doctrine of standing come from? It comes from the Constitution of the United States. The Constitution sets forth the authority of each branch of the federal government, the executive branch, the legislative branch, and the judicial branch. Article 3 of the Constitution is what covers the authority of the judicial branch, and it states that the judicial branch shall have jurisdiction to decide cases or controversies. Those are the magic words for standing, cases or controversies. And they seem rather broad, and I always tell my students that every case I've ever brought was both a case and a controversy, so I should have had standing in all of the cases I've ever litigated. But unfortunately, those terms have been construed over the years very narrowly to preclude many kinds of cases that we would like to bring on behalf of animals. The basic doctrine is that a case or controversy is only one that is brought by someone with a personal stake in the outcome of the case. Courts are not allowed to render policy decisions, advice, or recommendations to the other branches of government. They can only decide live controversies. This stems from a concern of separation of powers in the Constitution, and the judicial branch is not allowed to usurp the policy decisions of the executive and legislative branches. So the kinds of cases that are adjudicated under the standing doctrine are normally, and this is what the founders intended when they crafted the language in Article 3, those that concern some kind of traditional damage to someone. Economic damage is the classic example. If one has an economic stake in the outcome of a case, that person will normally have standing to bring that case. However, animals do not have economic interest usually in the outcome of cases, and so the question is, how does one use existing standing law to protect animals and to enforce these statutes that I mentioned? Before I turn to that, I want to stress that in all cases, the plaintiff has the burden of both alleging at the beginning of the case adequate standing, and then at the merit stage of the case, actually proving that the plaintiff has the requisite standing. So I'm going to discuss the law of standing to protect and advocate for animals and how it evolved over time, because that's important not only in terms of learning what the standing law is, but in figuring out new ways as we move forward to construct standing on behalf of animals. I'm not going to talk about what the standing rules should be, but instead I'm going to talk about what they actually are in the real world and how to apply them. I'm first going to discuss ways in which individuals versus organizations can establish standing to protect animals. And that is standing based on harm to an aesthetic or recreational or educational interest. And the genesis of this basis of standing started with a case that had absolutely nothing to do with animals. It's the Association of Data Processing Services Organization versus Camp case, a Supreme Court case that was decided in 1970. That case involved a challenge to the comptroller of the currency, new regulation that was promulgated that allowed banks for the first time to provide data processing services in addition to regular banking services. And prior to that case, the rule was that the plaintiff had to show, in order to demonstrate standing, that it had been deprived of a legal right to which it was entitled. And of course, the plaintiff data processing companies had no legal right to be the only ones that were allowed to provide data processing services. But nevertheless, they were harmed competitively by the new regulation that allowed banks to offer these services for the first time. And so the question was, did the data processing services companies have standing to bring this case? And in deciding that they did, the Supreme Court constructed a new test for standing that has become extremely important for all animal law standing cases. That new test is whether or not the plaintiff is suffering an injury in fact of some kind. In other words, one no longer needed to show that he or she had a legal right to something that had been invaded. The only question was whether or not the challenged action had caused some kind of injury of some sort to the plaintiff. And in constructing that new test, the Supreme Court recognized in a passage that has become very important that those kinds of interests could include aesthetic, conservational, and recreational interests. So significantly, the data processing decision broadened the kinds of injuries that will provide the requisite standing. 2 years later, the Supreme Court issued a decision in Sierra Club versus Morton, which has become extremely important for standing purposes. That was a challenge to the federal government's authorization of a brand new ski development by the Disney Corporation in a pristine area in California. After the data processing decision, the Supreme Court recognized, as it had to, that aesthetic interests were now cognizable under standing law. Therefore, the viewing of wildlife, for example, which was asserted by Sierra Club, was an important interest that could be protected under standing rules. In that case, however, the Supreme Court held that Sierra Club did not have standing, and the reason it held so was that it turned out that the Sierra Club had not shown that any of its members actually used the area in question. And therefore, the Supreme Court held there was no injury, in fact, because none of the actual members were injured by the authorization of the development. In doing so, the court stressed that a mere interest in a problem, no matter how strong it may be, was not enough. However, in a very famous dissent by Justice Douglas in that case, Justice Douglas said, and I quote, "The critical question of standing would be simplified and also put neatly into focus if we fashioned a federal rule that allowed environmental issues to be litigated in the name of the object about to be despoiled, defaced, or invaded by roads and bulldozers, and where injury is the subject of public outcry." He went on to say, quote, "The river, for example, is the living symbol of all the life it sustains or nourishes. Fish, aquatic insects, water ouzels, otter, fisher, deer, elk, bear, and all the other animals, including man, who are dependent on it or who enjoy it for its sight, its sounds, or its life." Justice Douglas was way ahead of his time, and unfortunately, his view of what standing law should be has never been decided by the Supreme Court, and although we continue to espouse that version of standing, right now we still have to live with what the Supreme Court has said is sufficient. After the Sierra Club decision, for 20 years, environmental groups could show that they had the requisite standing to protect animals in the wild by simply showing that they had members or individuals as plaintiffs who use the particular area at issue, who enjoy viewing the wildlife and observing it and studying it, and whose interest in doing so was somehow impaired by the challenged action at issue. A classic example of this is the Japan whaling case that was decided in 1986, in which individuals were challenging a decision by the federal government not to enforce whaling quotas under a treaty with other countries. And the court held that those individuals who could show that they enjoyed watching whales in the wild were going to be injured by the failure to enforce these quotas because it was going to reduce the number of whales that would be available to be observed. And that was classic standing. That was the kind of standing that the Supreme Court upheld over and over again. And then, 20 years later, in 1992, there was a decision issued by the Supreme Court in Lujan versus Defenders of Wildlife, which put a bit of a tweak on the standing rules that apply in these environmental cases. The Lujan case involved a challenge to a new regulation that had been promulgated by the federal government regarding Section 7 of the Endangered Species Act. That provision of the Endangered Species Act requires all federal agencies to ensure that any actions that they take or fund will not jeopardize the continued existence of a species that has been listed as endangered under the Endangered Species Act. And prior to the new regulation that was being challenged in that case, the rule that obligation applied to any federal action taken in this country, but also taken in other countries. The new rule changed that and said that from now on, this obligation no longer applies to any federal actions taken in other countries, for example, Sri Lanka or China. If the federal government was building a dam or funding a huge development project in those countries, it did not have this obligation to ensure that those actions would not cause the extinction of a species. Defenders of Wildlife wanted to challenge that regulation, and in the course of the decision that was issued by the Supreme Court repeated and stressed that there were three irreducible requirements for standing. The first is there has to be the injury in fact, and that again was established by the data processing case. The second requirement is the plaintiff has to demonstrate that the injury that's being alleged was somehow caused by the action that's being challenged, that the injuries are fairly traceable to the act being challenged. And the third requirement is that if the court rules in the plaintiff's favor, the court will be able to redress or provide relief in some form for the alleged injury. In that case, Defenders of Wildlife said the usual things that the environmental groups have been saying for 20 years since Sierra Club versus Morton. They had members who like to go to these countries, who like to look at the wildlife, whose ability to do so was going to be impaired by federal actions taken abroad. But in that case, those individual members were actually deposed. They were put under oath and cross-examined about the extent of their alleged injuries. And in the course of those depositions, it became clear that those plaintiffs, those individual members of Defenders of Wildlife, while they had been to these countries in the past, had not been to these countries in many years and had no concrete plans to return to the countries in the near future. Because the members could not show that they had any immediate plans to return to the countries at issue, the Supreme Court held they did not have standing to pursue that case. And the court stressed that this is because, for standing purposes, the injury cannot be a past injury. It has to be either a present injury, a continuing injury, or an injury that is imminent, something that is about to happen. And because of that ruling, the case has been known as the one that required the plaintiff to buy a ticket to the country at issue. In the course of the decision, however, although the court ruled that the plaintiffs did not have standing in that case, the majority, in an opinion written by Justice Scalia, made some extremely helpful observations about the kinds of injuries that would satisfy the standing requirement. And those are passages from the opinion that are heavily relied on in all animal protection cases that have occurred since then. Justice Scalia said, for example, quote, "Of course, the desire to use or observe an animal species, even for purely aesthetic purposes, is undeniably a cognizable interest for purposes of standing." Justice Scalia also said, quote, "It is clear that the person who observes or works with a particular animal threatened by a federal decision is facing perceptible harm, since the very subject of his interest will no longer exist," end quote. Up to that point, no court had ever ruled on what was required to establish standing to protect animals in captivity versus in the wild. Yet these passages that I just read to you have become extremely important in those endeavors. And I will discuss how we have used those observations to establish standing to protect animals in captivity. Now I'm going to discuss how to use the law of standing that was developed in the environmental context to protect animals in captivity. The first significant case was the Animal Legal Defense Fund versus Glickman case that was decided by the United States Court of Appeals for the D.C. Circuit in 1998. Several years after the Lujan decision was decided, the Animal Legal Defense Fund wanted to bring a case to challenge the United States Department of Agriculture's issuance of a new regulation that was intended to implement a congressional directive in the 1985 amendments to the Animal Welfare Act that the USDA promulgate a standard that would promote the psychological well-being of primates used in exhibitions, primates used in research, and primates used in the pet trade. Instead of promulgating a regulation that actually set the minimum standards that would be required, for example, requiring that the animals be housed in social groupings, that they have lots of enrichment to play with, to observe, to climb, etc., the USDA had issued a rule that basically left it up to each regulated entity to come up with their own quote-unquote enrichment plan in accordance with currently accepted professional standards. And the Animal Legal Defense Fund wanted to challenge that regulation as violating the directive of Congress. And the question was, who had standing to bring that case? And the reason standing is difficult in the captive animal context is that unlike plaintiffs who want to complain about an action that is going to reduce the number of animals in the wild that will be left to be observed or studied, one cannot make the same kind of argument when talking about animals in captivity, because the argument would be made that if there's a particular animal that you can't see in a zoo, a particular species you can't see in one zoo, you can just go down the street or go to another city and see those animals at another zoo. So that was a challenge in that case in terms of who could have standing. But one of the plaintiffs in the ALDF versus Glickman case was a man named Mark Chernoff, who was a humane agent and who had been to the zoo in question, the game farm, many times in the course of his work to investigate complaints about particular animals. And while he was there one day investigating complaints about the treatment of horses, his eyes were drawn to a chimpanzee named Barney, who was kept at the game farm in a barren cage with no other chimpanzees and no enrichment whatsoever. He watched Barney for several hours and basically became bonded with this animal. He wanted to do everything he could to help this animal obtain a better life and better conditions. He went to the United States Department of Agriculture and complained about the conditions that Barney was being held in. And every time he complained to the USDA, the agency said, no, they're in complete compliance with our current regulation. And on that basis, ALDF decided to go forward with this case and allege that, as in the environmental cases, Mr. Chernoff had an interest in viewing a particular animal and that animal was being treated inhumanely, and therefore it impaired Mr. Chernoff's aesthetic interests. The analogy was to someone who goes to a national park that they particularly like to enjoy, and because of a federal action that's being taken, development or the removal of a mountaintop, et cetera, their aesthetic interest in enjoying that national park have been reduced or destroyed. And in this case, that analogy was used to say that Mr. Chernoff has a particular interest in viewing this particular animal, Barney, and that those interests are being impaired by the inhumane treatment that Barney's being kept in. The district court in the Glickman case ruled in the plaintiff's favor on standing, but that decision was reversed by a panel of the United States Court of Appeals for the D.C. Circuit. And the plaintiffs then sought and obtained what's called en banc review, which is when the entire Court of Appeals then reviews the panel decision. The en banc decision held that, in fact, Mr. Chernoff had standing to bring that case. In doing so, the court held that he had demonstrated a sufficient injury in fact, which was the assault on his senses when he viewed this particular animal with whom he had bonded in inhumane circumstances. In addition, the problem that had arisen in the Lujan case, where the plaintiffs had no plans to go back to the areas that were affected by the federal action they were complaining about, in the Glickman case, Mr. Chernoff had kept going back to the zoo because he loved this animal so much and he wanted to protect it. He kept going back time and time again. And so there was no problem with any past injury being not sufficient because his injuries, his aesthetic injuries in viewing this animal in inhumane conditions were present and continuing and imminent. As to the causation prong of standing, the DC Circuit held that the plaintiffs had demonstrated the necessary causation because the USDA was authorizing the very conditions that were causing the aesthetic injuries. And as to the redressability prong of standing, the court also held that that had been satisfied because if the plaintiffs prevailed in the case, this would mean that the game farm, the roadside zoo at issue, would either have to improve the conditions that Barney was kept in, or if it couldn't afford to do so, would have to transfer those animals elsewhere, and Mr. Chernoff could enjoy visiting Barney in his new home. There was an additional standing requirement that the DC Circuit addressed and then that I want to mention. It is not a constitutional requirement as the other three requirements are, but it is what's called a prudential consideration that the court takes into account, and that is whether or not the plaintiff's injuries fall within what is called the zone of interest of the statute that is being invoked to bring the case. And in the Glickman case, there was no problem with this because, of course, the zone of interest of the Animal Welfare Act was to ensure the humane treatment of animals, and particularly animals that were held for exhibition. And therefore, Mr. Chernoff's injuries fell well within the zone of interest of the Animal Welfare Act. The next significant case was the Ringley Brothers case that was brought in the year 2000. That case involved a challenge to certain practices by the Ringley Brothers and Barnum and Bailey Circus with respect to Asian elephants. Asian elephants are listed as endangered under the Endangered Species Act, and the Endangered Species Act prohibits any practice that will either kill, harm, harass, or wound a listed species. And the plaintiffs in that case wanted to challenge these practices as violating that prohibition. The question was, who would have standing to bring that case? At that time, an individual named Tom Ryder had recently left the circus. He had worked with the elephants at the circus for several years. He had grown to love the elephants, but he didn't like the way they were treated. It caused him a lot of anguish and concern, and he wanted to do whatever he could to help those elephants. The problem was, because he had left the circus, there was a concern that the plaintiffs would not be able to show standing because of the ruling in the Lujan case that I spoke about earlier, where the plaintiffs were held not to have standing because they had no intention to return to the foreign countries where the federal actions that were causing them harm were occurring. However, a few months after Mr. Ryder had contacted the animal protection groups to do something about these elephants, the Supreme Court had decided another case called Friends of the Earth versus Laidlaw Environmental Services, and this is a case that was decided in 2000. This case involved plaintiffs' challenge to a violation of the Clean Water Act. The plaintiff, Friends of the Earth, and other organizations were complaining that a particular river was being polluted because of violations of the Clean Water Act, polluted with mercury. And the question was, who had standing to bring that case? And in that case, the members of Friends of the Earth had used the river when they were young. They had gone fishing in the river, they had gone swimming in the river, they had canoed in the river, but they were no longer using the river because of their fear that it was polluted with mercury. And the Supreme Court, in a decision issued by Justice Ruth Ginsburg, held that this concern about the pollution was enough for the requisite injury in fact. And the analysis was, these individuals would like to use this river again that they used to use when they were young, but they're not using the river because they're afraid it is polluted. And they have this Hobson's choice. They can either jump into the river and get polluted with mercury, or they can refrain from using the river that they would really like to enjoy using. And the Supreme Court held in a very close decision that that was enough for the requisite injury in fact. The plaintiffs in the Ringley Brothers case then used that analogy to establish that Mr. Ryder had standing to bring a case challenging these practices by the circus vis-a-vis the Asian elephants. The argument was that Mr. Ryder was also forced to make a choice. He could either continue to visit the animals and see them in what he considered inhumane conditions, and he was able to tell, because he knew them so well, that they were suffering from the conditions under which they were being kept and forced to perform acts in the circus, or he had to refrain from visiting the elephants that he had come to love, and that was enough for the kind of injury in fact that was required for standing. On a motion to dismiss, the district court ruled that Mr. Ryder had no standing, and then that case was then appealed to the United States Court of Appeals for the D.C. Circuit. And the D.C. Circuit reversed the decision and, analogizing to the Laidlaw decision, held that Mr. Ryder had the requisite standing to bring that case at the motion to dismiss stage. After the D.C. Circuit's ruling, basically applying both Glickman and Laidlaw, the court held that individuals who enjoy visiting particular animals and whose interest in doing so will be injured by the challenged action have standing to bring those cases. And also, individuals who enjoy visiting particular animals but are refraining from doing so in order to avoid more aesthetic injury also have standing to bring cases challenging actions that will impair or injure those animals. However, in the Ringling Brothers case, after many years of litigation and a very long trial on the merits, the district court stuck to his original conclusion that Mr. Ryder did not have standing based on a credibility determination that Mr. Ryder, he did not believe, truly loved the animals at issue. By the time that case had ended, and even though the district court judge ruled that there was no standing after all, we had produced so much evidence of the mistreatment of the elephants and shown to the public that, in fact, this is the way they are treated and kept in control by the circus, that the public became aware of these practices, stopped going to the circus, and as a result of all of that, the Ringling Brothers Circus stopped using elephants in May of 2015 and stopped using all animals in circuses in 2017. I only mention that because it's important sometimes to stress that you can bring these cases, and even though you may lose on the merits and lose the battle, you can win the war. And that's exactly what happened in that case. So after the Glickman decision, and after the Ringling Brothers decision, it became possible to establish standing to protect animals by having a plaintiff who either enjoys observing a particular animal in captivity and would like to continue to observe and study that animal, but who is injured by a federal action that is being taken that causes the inhumane treatment, or it could be an action by a federal defendant as well, and that doesn't have to be the federal government. Or a plaintiff can show that even though they're not currently visiting that animal, they would like to continue to visit that animal, but have to refrain from doing so in order to avoid more aesthetic injury. I've discussed ways to establish standing in federal court for individuals who are suffering aesthetic or recreational harm. And I now want to address an additional basis for establishing standing in animal protection cases, and that's under the doctrine of informational injury. Informational injury occurs when a statute or a regulation gives you a right to information, and that right has been denied, and that can form the basis for the requisite injury in fact. The classic example is the Freedom of Information Act. That statute allows any person to request information from the federal government and requires the federal government to provide that information unless it's exempt from disclosure under one of the 9 exemptions to the statute. And if the agency refuses to disclose the information, or there's a basis for claiming that the exemption has been wrongfully invoked, a person can file a lawsuit and they can establish standing because of the denial of the information. Informational injury has been used as a basis for protecting animals. A classic example is Friends of the Animals versus the Fish and Wildlife Service. This was a District Court of D.C. case that was issued in 2009. In that case, the plaintiffs were challenging a special rule that had been issued by the Fish and Wildlife Service exempting these entities called canned hunting ranches from the requirements of the Endangered Species Act with respect to the breeding and killing of exotic antelope species that are listed as endangered at their canned hunting ranches. These are ranches that are completely enclosed by fences, and the animals have no ability to escape. And the proprietors of these ranches allow individuals to come to the ranch, pay a fee, and quote unquote hunt one of these exotic antelopes and then kill it and take home the trophy for their possession. And what happened in that case was, even though these antelope species were listed as endangered, and these are 3 antelope species that live in the wild in Africa, but they were being bred for these captive canned hunting ranches, even though they were listed as endangered, the Fish and Wildlife Service issued this special rule that said none of the requirements of the Endangered Species Act will apply to these animals. And so Friends of Animals and some other plaintiffs wanted to sue the Fish and Wildlife Service for issuing that unlawful regulation. The way they established standing was through informational injury. Section 10 of the Endangered Species Act provides that anyone who wishes to engage in an otherwise unlawful act under the statute, which would include killing an endangered species, has to apply for and receive a permit from the Fish and Wildlife Service. And the Fish and Wildlife Service can only grant such a permit if it is necessary to enhance the propagation or survival of the species at issue. In that case, because the canned hunting ranches had been completely exempted from the requirements of the Endangered Species Act, the Fish and Wildlife Service was not requiring these ranches to apply for and receive a Section 10 permit, nor could they possibly demonstrate that allowing the hunting and killing of these endangered antelopes would somehow enhance their survival or enhance the propagation of the species. And so the plaintiffs sued, and the basis for standing was that this Section 10 requirement includes an additional requirement that provides that the Fish and Wildlife Service must give to the public at every stage of the proceeding not only the application that was submitted, but all of the information that was submitted in support of the application for a Section 10 permit. And so the plaintiffs successfully argued that the denial of this information that was required by statute was enough for injury in fact. And as a result of bringing that case, they were able to successfully challenge the exemption that the Fish and Wildlife Service had issued. I do want to add that the Freedom of Information Act is also used extensively to protect and advocate for animals. For example, groups often use inspection reports that have to be issued under the Animal Welfare Act in order to track the zoos that are in violation of those standards, or perhaps even violating the Endangered Species Act, and use that evidence as a means for bringing lawsuits against those zoos. In addition, FOIA has been used to obtain all kinds of very important information about wildlife import and export data in an effort to track and cut down on the black market in wildlife trade in this country. And the beauty of informational injury up to this point has been that all you have to show is that you have a right to information that has been denied, and that's enough for injury in fact, and that's enough for standing. However, I do want to caution that last term, the Supreme Court issued a decision under the Fair Credit Reporting Act, TransUnion LLC versus Ramirez, which held that the plaintiff in that case did not have standing. And in the course of issuing that ruling, the Supreme Court mentioned that it may be that in the future, anyone who wishes to assert informational injury as the basis for standing will have to show some kind of additional underlying injury in fact that results from the deprivation of the information at issue. However, that's not going to be a problem for most animal protection groups who seek information under the Freedom of Information Act. All they'll have to do is allege that not only was the information denied to them, that is statutorily required to be provided, but the lack of that information has harmed their ability to advocate for the animals. I've discussed how to establish standing on behalf of individuals, and now I want to talk about how to establish standing on behalf of organizations, because there are a lot of organizations out there that are devoted to the protection of animals, and they need to be able to get to court, if necessary, to enforce the laws that were enacted for that purpose. There's two ways to establish standing on behalf of an organization. The first is called representational or associational standing, and that is when an organization represents the interests of its members in a case. The leading case for this is Hunt versus Washington State Apple Advertising Commission. Again, had nothing to do with animals, a 1977 decision by the Supreme Court, where the Supreme Court held that an organization who is representing the interests of one or more of its members has standing as long as that member's interests are germane to the overall interests of the organization. In those cases, the same rules that apply to an individual when establishing standing that I've already discussed apply in the context of representational and associational standing. In other words, you have to demonstrate that the organization has one or more members who meet those standing requirements for individuals. And I will stress that the members have to be actual members who have some kind of input into the organization's issues and decisions. Supporters or contributors or simple fans of the organization will not be sufficient to establish this kind of standing. You have to demonstrate that the members actually have input on the issues of the organization, and that is usually satisfied by demonstrating that the members pay dues to the organization. A second way for an organization to demonstrate standing is if it can show that the organization itself has been injured by the challenged action. The leading case is Havens Realty Corporation versus Coleman, a 1982 case, which again had nothing to do with animals. It was a case challenging illegal steering practices under the Fair Housing Act, whereby owners of apartment complexes were offering vacancies to white people, but denying that there were vacancies when people of color were seeking apartments. And the organization representing the individuals wanted to establish that they had standing in their own right to bring this case. The argument was that this organization spent a lot of resources and time and effort in counseling members of the minority community that they had a right to equal housing under this statute, and that those counseling efforts were being undermined by these unlawful practices. And as a result of those unlawful practices, the organization now had to spend additional resources to counteract these practices. And the Supreme Court held that this kind of concrete and demonstrable injury to the organization's activities, coupled with a consequent drain on the organization's resources, was enough to establish the requisite injury in fact for standing. This kind of organizational resource drain standing has increasingly been successfully used in animal protection cases in the last few years. The basic argument is that the defendant is doing something unlawful that undermines the mission of the organization, and as a result, the organization has to spend additional resources to counteract that injury. An example of this is the PETA versus USDA case, People for the Ethical Treatment of Animals, which was decided in 2015 by the United States Court of Appeals for the DC Circuit. In that case, PETA challenged the USDA's failure to regulate birds under the Animal Welfare Act. Congress had passed a statute in 2002 amending the Animal Welfare Act to make it clear that birds not bred for research were supposed to be covered by the requirements of the Animal Welfare Act. And yet, the USDA for many years refused to issue standards that applied to birds, and the inspectors were taking the position that birds still were not covered by the Animal Welfare Act. And therefore, PETA wanted to sue the USDA for its failure to regulate with respect to birds under the statute in violation of the statute. And the question was, did they have standing to bring that case? And the court ruled that, using the line of reasoning under Havens, PETA had established the necessary injury in fact because PETA could show through detailed declarations that because the USDA was not enforcing the statute with respect to birds, PETA was being denied very important information it needed to carry out its mission to protect birds, and it was also being denied the ability to file complaints with the USDA with respect to the treatment of birds, and that all of that undermined PETA's basic mission, which is to protect animals from abuse, neglect, and mistreatment. And PETA was also able to show that as a result of those unlawful practices, it had to shift resources from other programs to counteract the practices and to obtain the information it wanted about the treatment of birds from other sources. And because it satisfied the two requirements of Havens, the DC Circuit held that PETA had demonstrated the requisite standing. I will say that there's a difference among the circuits as to how exactly this kind of standing is construed. And it may be something that is challenged in the future in the Supreme Court. Keep your eye on that. But for now, it has been shown to be a very fruitful avenue for establishing standing on behalf of an organization that wishes to protect and advocate for the interests of animals. I want to end with some additional points about standing. The first is to talk about a concept called procedural standing. This arises when an agency fails to follow a procedure that is required by law. A classic example would be the failure to prepare what's called an environmental impact statement under the National Environmental Policy Act. That statute requires agencies, all federal agencies, to prepare an EIS with respect to any federal action that may significantly affect the environment. In the Lujan case that I discussed earlier, the Supreme Court held in a footnote that in those cases, plaintiffs do not have to show that if the procedure had been followed, it would necessarily have meant that the injuries that are asserted would have been redressed by the agency. You don't have to show that you would win the case if the procedure were followed, that the agency would come out with a different decision, for example. It's enough that the agency failed to follow the procedure required by law. However, in those cases, the Supreme Court has said that the plaintiff would have to show that as a result of the failure to abide by the requisite procedure, the plaintiff suffered some kind of additional concrete injury. And the classic example that it's actually given in the Lujan decision is people who live near a dam that is going to be built, who are opposing the dam because it's going to ruin their environment. And they challenge the agency's failure to comply with the National Environmental Policy Act by failing to prepare an environmental impact statement. Those individuals would have the ability to go to court and sue the agency for violating the procedure that is required by law because they have a concrete interest at stake. And the second thing I wanted to mention is standing under state law. I've been talking a lot about standing under federal law, which again arises from that constitutional provision that gives courts jurisdiction over cases and controversies. That provision doesn't apply to states unless the state has adopted a similar kind of provision in the state's own constitution or some other basis for standing in the state's constitution, or the state has issued statutes or through common law has established specific standing requirements. So if you're going to bring a case in state law, under state law, you have to know what the standing requirements are that apply to that particular state. For example, every state in the country has an animal cruelty code that prohibits the abuse and neglect of animals. That term animal is defined differently under those statutes, and states have various exemptions, but they all have that basic requirement. And the question is, how are those prohibitions enforced? In most states, pretty much all of the states, the only way those cases can be brought are by local prosecutors. They're the only ones who can bring those cases. Individuals and organizations do not have standing, cannot bring cases challenging violations of the state cruelty codes. There are a couple of exceptions. Pennsylvania and North Carolina both have specific standing provisions in their state animal cruelty codes that allow particular individuals to bring those cases. And in addition, in Connecticut and Maine, there are statutes that allow lawyers and students to represent animal interests in cases that are brought by the local prosecutors. They can't bring the case on their own, but pursuant to those provisions can assist the local prosecutors in producing evidence, cross-examining witnesses, and that kind of thing on behalf of the animals. And then other courts sometimes allow what are called guardian ad litems to come in as representatives of the animal's interest in an animal cruelty case, particularly, for example, when the question of how to dispose of an animal, where it should go if it's being taken away from an abuser, where it should be placed. In those kinds of cases, sometimes courts will allow a guardian ad litem to come in and represent the best interests of the animal, much like is done in, for example, child neglect and abuse cases. So I've explained the basic rules that apply to standing and the evolution of those rules as they apply to using standing to protect animals under the law. And until animals are given their own rights to assert their interests and rights in court, we are going to have to continue to rely on these standing principles that humans employ to protect the interests of animals and continue to come up with innovative ways to expand the standing rules that allow those cases to be brought. This is Katherine Meyer for the Animal Law Fundamentals.